talking a lot about plea bargaining because in plea bargaining, the victim's sentiments and the families of the victims in the case of murder are taken into consideration, or should be taken into consideration. Senator Campbell.
Mr. Chairman, thank you. And I must apologize for being late this morning. I had obligations elsewhere. I am looking at the data that I am assuming it has nothing to say who it comes from, but I'm assuming...
No, it is from from the court administration.
Well, it doesn't say so, sir. And it's the second time it has been provided
it's from the court
without
administration
it saying so. But that said...
It's statistics prepared in the courts, from the courts.
Yes, sir.
It came with a cover letter, which should have been circulated.
Okay. And I had, if members will recall, written and asked that this data be broken out. And I'm looking at it now. The incidents of murder in relation to the total number of charges filed involving minors 17 and under, accounting for 0.87% of the total cases, yes.
For children before the courts.
For children before the courts. I look at the page following, and table 2, the charges. I'm not sure why court administration keeps insisting on including the frequency of other charges, because this committee is concerned with the offense of murder. But this, even in this compounding of all charges together, charges filed across the parish courts involving minors by age, 15 to 17 is the age group that is 80%, 11 to 14, 17%, and 10 and under, 1.6%. I'm cognizant, Minister, of the emotions of the public and the sentiments that the public have whenever there is a murder. And certainly when it involves a child, it is always shocking to the conscience. And the response is usually disbelief and outrage, and the public very openly often expresses their emotions, whether it's through the media, in the communities, or whatever. But I do believe that while those incidents elicit that response, the purpose of the law is not to treat with our every emotional response to an incident, but to determine what is it in the society that can be and needs to be corrected by legislation. We have, when those outrageous things happen, usually we hear that the child had a mental condition or some such the like. That child who is willing to commit that terrible murder for that reason is not going to be impacted by a mandatory minimum sentence. Because of their condition, they are going to be more likely than not to do what they would do whether the law exists or the law does not exist. And I am wondering, I'm looking at the situation with children. I know my colleague, Senator, who is a psychiatrist, has remarked, she and I have had discussions about this. And I can't, when we put a child in prison for murder, without allowing the court the discretion to determine the circumstances and what punishment should ensue, we basically say we're locking them up for 20 years. There's no rehabilitation in that. There's no recovery of that child. We have condemned that child.
If you don't mind, we want to come to that in a short while.
Come to what?
No, you were, no, what we're saying, we're going to go through these preliminary observations and then we start making some decisions, okay?
Okay.
So without, I mean,
well, I'm sorry, I came in late and I heard the conversation that was happening. I was simply seeking to add my voice to it.
No, let me just add, what we would like, that the discussions, if we go through, I had said at 10:30, we could go through the matrix.
Okay.
Quickly for the first hour.
May I have a copy of the matrix, please?
And then immediately we start having a good, wide-ranging discussion.
Very well, Minister.
Primarily today on children, the appropriate sentence for children.
Very well.
Okay? And then we can finish up tomorrow, but tomorrow we are going to do also the final decisions and sentencing generally, okay? Because we want to report back to Parliament, all right? Sorry, Minister, go ahead.
Okay. Mr. Chairman, I'd love for us to get from the prisons a listing of the various programs that happen within the prison, the rehabilitation that happens, because there seems to be this misconception that nothing happens, you just get put into a cell and that's it, and then we are saying, lock you away for 20 years before there's a decision about parole. But it would help if persons understand that I believe that within the prisons
we can come to that.
The rehabilitative works that happen.
We'll try and get some information on that, hopefully for tomorrow's session. Remind us to discuss with the Minister of State, to just give us... who's the Minister of State again? Let me have a discussion with her if she could get some information. You did. And, right. Anyway, let's go through very quickly the matrix. So Jamaicans for Justice, in its general observation, proposed that using a presumptive approach to insert safety valves to preserve judicial discretion and avoid miscarriage of justice, provide relief in exceptional or substantial or compelling circumstances, re-legislate starting points based on aggravated factors, reduce minimums for guilty pleas. Recommendation: sunset clause should be inserted if the current approach must be employed. Consider the potential effect, CPC, make a note of that first. They want sunset clause for whatever minimum we're suggesting, okay. SG?
Yes, but it wouldn't be for the CPC to note something. The committee would have had to take a decision before CPC gets involved.
Sure, okay.
And so just this whole thing of running through the matrix, if the committee doesn't indicate exactly what decision, because everything has to be, you have to take a decision on all the different recommendations. If you don't do it today, you're going to have to go back through the matrix again to do it. So I hear you saying running through the matrix, but I'm just saying at the end of each point, the committee has to take some sort of decision on each recommendation.
What I had indicated is that we go through the general observations and have a preliminary discussion, because we can take them some pages at a time, all right? But I'm not too sure that these are general observations.
So at the end of reading a general observation, the committee should decide whether or not this is a recommendation being taken on board and how, whether you mean an amendment to one of the 3 pieces of legislation or you're referring it back to a ministry or something, but you have to take some sort of decision. If you don't do it today, you're going to have to do it another day. Ms. Brandon will remind you, If she doesn't have the decisions recorded, she's going to remind you at another point. So I'm just telling you from now.
No, with due respect, SG, I noted. The point is that these are contributions to determine whether we make certain decisions and minimum mandatory for children. So the decisions to be taken is whether or not we take certain decisions and the age group, 12 to 17. I think later on a recommendation was made by, I think, Jamaicans for Justice, that 12 to 14, there should be no mandatory minimum. But they also recommended 15 to 17, that there should be mandatory minimum. However, they did not support the 20 years. I think somewhere along the line. So all the decisions that the committee has to make later is whether minimum mandatory for all 12 to 17, or for one age group 12 to 14, or no minimum mandatory. I think that's the decisions.
Thank you, Chair. But if you look on page 1 at the bottom of the first recommendation from the Jamaican Psychological Society, it proposed some amendments to the Act. So all I'm saying is, I hear what you're saying, but some of them don't relate into these nice little categories that you've just referred to. So I'm just saying at the end of the day, the committee still needs to decide what they're doing with all these different recommendations as you go through them, which is a normal course.
We could. We can say noted, or, we don't support. For instance, in these general observations, the Jamaica Bar Association is recommending that there should be no minimum mandatory. I would say personally, and I hope we can support it, right? There should be minimum mandatory sentences. In relation to the Psychological Society and the Youth Advocacy views that there should not be incarceration for youth offenders, for murder, there's no way there has to be some form of incarceration, call it institutionalization. So those recommendations cannot then be supported. All right? So those are the positions in relation to those views. Now, Jamaicans for Justice, just to finish up, and then we can make a decision on that one. Sorry.
I understand what SG would have been saying, because you have the various stakeholders that would have come and represented their submissions and recommendations. And as a committee, we have to take a decision in relation to what those recommendations are. I would have said earlier that there are some recommendations that are more policy-driven in nature. That is and we have to determine if we are going to take that on as a policy. Whether we're going to accept it, park it, or reject it. And there are some that proposes an amendment to the legislation, however, not defined in terms of the extent. But again, we have to make a decision. And what I gather she's saying is that it might have been easier now to make the decision on each one.
Well, no,
because I know the SG is going to come back to you tomorrow afternoon and say, what is the decision that was taken on this specific one? So in order to prevent that, Chair?
Because, you see, I must admit.
Is that a reasonable representation, SG?
Definitely. So we do it on each one. I was hoping we would do it across the board. I was hoping we would do it across the board when we listen to all. But I don't have a problem, we go for specific. So in relation to Jamaicans for Justice, they recommended a sunset clause, considering the potential effect the proposals may have on human rights and the rule of law. It is submitted for a period of 5 years for the current proposals, with substantive review beginning after 3 years. As part of this review, robust discussion must be had amongst correctional and judicial officers who implement the legislation as to its effect. Recommendations: consider other related legislative. Let me just finish it. Consider other related proposals. These include: conduct research to explore possibility of a sentence review committee comprising of judicial officers, conduct a comprehensive review of the sentencing guidelines, conduct a wider review of statutory offenses to ensure proportionate sentencing, consider tiered sentencing for rape based on aggravating factors, improving legal aid rates, removing legal aid exemptions, and providing legal aid at the Privy Council. JFJ urges the government to ensure resources and attention be placed more heavily in the effort to understand underlying factors driving the ballooning crime rate and the increased utilization of preventative approaches through social programs, social and financial support, and investment in education. Legislative proposal allow for reduction of mandatory sentences for guilty pleas under the Criminal Justice Administration Act. Section 42E of the Principal Act is amended by inserted subsection 4 to state: where a person pleads guilty in the first instance, subsection 3 does not apply, and the judge may have discretion in regard to the starting point of the sentence. Section 42E of the Principal Act is amended by inserting subsection 4 to state: where a person pleads guilty in the first instance, subsection 3 does not apply, and the court may impose a sentence that is no less than 70% of the mandatory minimum sentence specified in law. There's no doubt that Jamaicans for Justice support the mandatory minimum. They said so, okay? There are certain matters over which we have no control. Sentencing guidelines and sentence review committee comprising of judicial officers is a matter for the Chief Justice. So there's very little. Consider tiered sentencing for rape based on aggravating factors, a matter to be considered when we look at the Sexual Offences Act, but not at this time. Improving legal aid rates. Legal aid rates have been doubled over the past year or two, okay? I don't think there are many lawyers complaining now about legal aid rates. In fact, interestingly, we have been begging lawyers to send in their certificates so we can pay out. I mean, yes. I can tell you, this year in January and February, we had money remaining in the legal aid budget. And we had to be writing and telling lawyers, if you have certificates, send it out. And I don't think any attorney can now complain that they have done a legal aid and they have not been paid. In fact, even the gang trial that just completed, the lawyers and myself agreed on a rate, and they have been paid up to date. Maybe the sentence, the last couple of days, they have not been paid, but there are funds to pay that. So I can say that has definitely been satisfied. Providing legal aid to the Privy Council, that's a matter for consideration, but at the moment, what is afforded could not take matters to the Privy Council, because if we pay $270,000, say, for a murder trial, or the same rate to go to the Court of Appeal, it would have to be about 5 or 10 times that amount to go to the Privy Council. Or this, so I can't see that approval at the moment, but it is something for consideration. The position is JFJ urges the government to ensure resources and attention be placed more heavily in the effort to understand the underlying. That's a matter, I'm still on Jamaicans for Justice. The truth of the matter is that that's a matter that the government has under consideration, how various social programs can be used to assist in what we discussed earlier, to change views, as in fact they're supporting, you know, that guilty pleas should be recommended, more guilty pleas to be recommended. Truth of the matter is that, as I've said before, I would like to see guilty pleas come under the Plea Bargaining Act rather than under the Criminal Justice Administration Act, where all issues can be taken into consideration rather than just an arithmetic figure that once you plead guilty, you chop off 30%. I believe that if it comes under the plea bargaining, all the issues can be taken into consideration without using an arithmetic formula that if you plead guilty early, you get 50% or 35%. That may happen after the negotiation under the Plea Bargaining Act. So basically, these are matters which we will come to in deciding whether we agree with the recommendation that guilty pleas should be dealt with, how guilty pleas should be dealt with. So that's Jamaicans for Justice. If there are no other points to note, I will move to the Child Watch affiliate of Hear the Children Cry. Recommendations: it is suggested that the government allow the court to exercise its judicial powers to determine matters on its own merit relating to each child and the sentence that should be applied. Children, despite conviction, should be treated with consideration to their rights, and therefore, even in serving their sentences, they ought not to be placed in an adult facility, but be placed among their peers in a youth facility. Recommendation: to inhibit the likelihood of rehabilitation being disregarded, it is recommended that in the event of sentencing, we take notes from our international friends who have imposed sentences in tranches based on the age range and having the primary goal of sentencing being that of rehabilitation. It is suggested to invest more time and effort into programs and avenues where youths at risk may be positively engaged prior to join in criminal gangs and participation at criminal activities. I think our discussions earlier reflected what they were saying, that we could look at the age group in terms of the minimum mandatory, but also to urge that juveniles, that when they're sentenced to incarceration, that there should be programs for rehabilitation and, reformation inside the institution. So after a period in the institution, they return to the society as an adult in a better condition than when they entered. So that is something which we should bear in mind when we get to our final decision. The Office of the Director of Public Prosecution's recommendation, Section 20 of the Plea Negotiation Agreement Act, states that the prosecution may enter into negotiations with a person convicted of a crime and serving a sentence. It is our recommendation that the proposed amendments expressly state that they do not repeal, replace, or limit the scope of Section 20 of the Plea Negotiations and Agreements Act. It would be appropriate to delineate variances between the mandatory minimum for murders committed in circumstances where Section 2(1)(a) to F and Section 3(1)(a) applies. Here, the DPP is saying we leave the Plea Negotiations Act as it is, unlike what occurred in the Firearms Act. In the Firearms Act, the plea negotiations was deliberately adjusted to say that only if the offender gave information to the Crown to implicate others or information of a substantial basis that they could not benefit from the plea. In other words, in the Firearms Act, plea negotiations only available for a lesser sentence if the offender inform on others or gave substantial information to the Crown which would assist in solving crime or exposing, guns. So what the DPP was saying, the recommendation is that we don't put that in the act, okay? And personally, I agree. In other words, a person who pleads guilty to murder should get the benefit of whatever is negotiated that is sanctioned by the Crown, the prosecution, the defense, and by the judge. You see, so that's the point.
Is the Plea Negotiation Act up for review?
I don't think we have a sunset clause, but normally most legislation.
5
Remember,
years.
it was passed in 2017. 2017, and
2017.
yeah, it was passed.
Because a lot of these recommendations that you're speaking of could essentially come under maybe proposed under the review.
Well, it has been working,
Yes,
But
but not to the extent that you are desirous of. And as I've indicated earlier, it's really a journey and an understanding and an acceptance of it.
You see, I think the Chief Justice and the DPP are concerned now that we are not getting more pleas in the gun court. You see, before the recent Firearms Act, there were many pleas, guilty pleas, because offenders usually get between 5 and 10 years. But now, because the mandatory minimum is 15, they're not getting the pleas because people will take a chance, you see. Well, the only incentive which was put in was that they must help to say where they got the gun from, who they got it, you get me? So in other words, the offender can come within the Plea Negotiation Act if they help the Crown to solve crime. So, but unfortunately, many don't want to be an informer.
With the amount of reprisal killings which you have and gang warfare, how would anybody expect that you are going to start to create a culture of informer by putting it in that legislation? And everybody going to know as you do it? We live in a society with certain cultural aspects which we must take into account. When we were doing the Joint Select Committee, I pointed out that you would not get any pleas. Because if you're going to risk 15 years, why would you plead? And secondly, that under the only olive branch, if you can call it that, which was granted, was that plea. And you would have to give up somebody in circumstances where you have your family out there, and you know nowadays that you're putting an entire family at risk. Minister, respectfully, I'm imploring you. There are some things we do that just don't make sense, and that is one of it. We just need to rethink it.
Well, that is present the law, So the question is whether it should be revisited, is your point.
Because it must be creating a serious backlog in the courts. Everybody is, to me, as somebody who has practiced in the criminal courts, an accused man is going to take his chance. That on some technicality, witness don't turn up, police don't turn up, something happens. He's going to take his chance because he has nothing to gain from pleading guilty.
Are you saying that if he pleaded guilty and he could get 5 years off instead of 15, he gets 10 years? There's a likelihood.
I'm not saying how many years. I'm not going to be so presumptuous. But I'm saying that there has to be an incentive for somebody to plead guilty. And if you look at the clear-up rates in the courts, you will see that most of the matters are disposed of because people pleaded guilty. It's not a trial.
I think, though, Senator Motley, you were in that committee. The concern of the committee and the Parliament, we have such a serious problem with firearms. Guns are proliferate almost in every community. And the question is, that law of a 15-year minimum mandatory was meant to send that signal that from you have a gun, you must recognize once you're caught, you're going to serve 15 years. No. It's a matter, if they plead guilty, it would save the court a lot of time. And that would be of assistance. But how the law was crafted was that, yes, you can plead guilty, you can benefit, but you must say where you get the gun, because it will assist, the state in reducing the amount of guns within the state. Okay, the final contribution was from the Jamaica Psychiatric Association. Yes, Mr. Bean.
I just wanted to make a comment in relation to a question that was asked before, whether or not the Plea Negotiation Act is subject to review or should be subject to review. And there's a provision that requires that the first review shall be conducted not later than 5 years after the date
so
of
it's due for review.
So it is due for review presently. Okay. And I also wanted to make a distinction between what would have obtained under the Firearms Act and what is being proposed now. So with the Firearms Act, there was an exclusion to the provisions of the Criminal Justice Administration Act. We're not seeking to do that kind of exclusion, no. Yes. I very much so remember.
Okay.
So what is being proposed as the amendment is that the court cannot impose, if it is that there's a guilty plea, the court cannot impose a sentence that is less than 30 years. So the question is whether or not the 30 years is appropriate as an incentive to the accused.
That is under the Criminal Justice Amendment Act. My position is that we should remove that and leave everything to the Plea Bargaining Act. No. What happened is that, just to help you, Senator Binns, what we're saying is that one of the proposals in the bill is to the minimum mandatory, even if the person pleads guilty, should be 30 years under the Criminal Justice Amendment Act. My view is that we should remove that particular clause. In other words, eliminate that clause, which is what I was saying. Once you plead guilty, you come all the issues under the Plea Negotiation Act. You see, in other words, let the court, defense, prosecution, judge look at all the issues and make a decision in that particular case of a guilty plea, rather than say, as happens now, arithmetic figure, you reduce by 50%, 33%, and what was being proposed was to make it 30 years, because at the moment it is 20 years, I think. There's no figure. But for it to be consistent, we would have to put in a figure. So we are saying to avoid that, we repeal that particular section. The truth of the matter is that when we were tabling, when we were debating the Plea Negotiation Act, we saw the inconsistency with that Criminal Justice Amendment Act. But because we had only passed it in 2015, the Law Reform Department convinced me to leave it there for a while to see how it functions. But as I see it now, the Plea Bargain Negotiation Act has overtaken it. So let the Plea Negotiation Act deal with it. Yes, Senator Binns.
Mr. Chairman, you will forgive me because I do not practice at the criminal bar, so most of this learning, and perhaps it's good to see a different side of the law and hearing the conversations. But from the conversation, it appears to me, though, that the provisions in the Criminal Justice Amendment is the one that is being used more by defense counsel, and there is clearly an issue in terms of the operation or the utilization of the plea negotiations act. So if my observation is correct, based on the conversations taking place since this committee started, then I'd want to understand, without fixing the issues that affect the lack of use of the Plea Negotiations Act, why would we want to then take out the section in the Criminal Justice Act which is utilized more than the plea negotiation and make all of these guilty plea fall under the plea negotiation? I can't understand the benefit unless we are going to deal with the issues that exist that prevent defense counsel from utilizing the plea negotiations act more.
There are many reasons, sentiments. Firstly, under the Criminal Justice Amendment Act, defense counsel say we're pleading guilty, could be the first occasion, and the judge just impose the sentence. If the judge would say, I think the sentence for this should be 18 years. I'm taking off a third, and it's 12 years, without any reason. One second, let me just finish. The prosecution, in many cases, is not even consulted, and the right of the prosecution now can appeal. So that is a possibility. I know of many cases where, at the first instance, the accused pleads guilty. The witnesses are not even aware that the case has completed. Witnesses have complained, how is it the case finished and they don't give evidence? You get me? So in other words, it is too presumptive, where the plea is taken, sentence is passed, and nothing else is considered. And that is why I never favored it from the beginning, why the plea negotiations should overtake it, because at least all the issues could be taken into consideration. The sentence might be the same. Agreed? But it could be less. Yeah.
Thanks, Chairman. And Chairman, there may be very good reason for wanting us to utilize the plea negotiation vis-a-vis the criminal justice. But I wondered whether, again from the observation, whether the issue is legal or is it operational, because it seems to me from the discussion that it is not so much a problem with the law itself, whether it's the plea negotiations or the criminal justice, but it is just how both pieces of legislation operate. I mean, we hear earlier where persons spoke about the plea negotiation, a lack of trust, and the fact that there is this, the Crown and Defense Counsel can come to an agreement, but the court reserves the right to change that agreement, having considered all the factors. I don't, and I stand to be corrected because, as I said, I don't practice at the criminal bar, but from the conversation, it doesn't seem to me that it is so much a problem with the law, but just how both pieces have been operating over the time. Marty, there may be good reason for just doing the plea negotiations, but it seems to me that more needs to be done to ensure that the Plea Negotiation Act is used by counsel, that persons understand, and that the trust issue that was spoken about earlier, that is treated with.
Well, I really can't tell you that defense counsel favors the Criminal Justice Amendment Act, because if they can convince the accused to plead guilty, they have a fairly good idea that there's an arithmetic reduction, okay? But at the end of the day, how it has worked is that the society frequently feel that there were not good consideration in imposing the sentence under the Criminal Justice Amendment Act. Because you see, I think I've given you this example of a case on Old Hope Road where this fella had thrown the victim over the balcony. He was charged with murder, and there was a big outcry, And the judge started out by saying the sentence is 18 years. But because you pleaded guilty sometime during the course, 1/3 was cut off. So it went to 12 years. But the person was in custody for about 4.5 years. So you took another 4.5 years off the 12 years. So it ended up at about 7.5 years. So the man was sentenced to 7.5 years. Take it from me. There was a general outcry that a man charged with murder pleaded guilty to manslaughter and is going to serve maybe 5 years. You understand? Now, it might sound reasonable to the defense and to the accused. That is a case where if the right of appeal for the prosecution was in existence, the prosecution could appeal, because the prosecution was a bit worried. Because the sentiment was, it was a horrible murder or killing. He pleaded guilty to manslaughter. Under the Plea Bargaining and Negotiation Act, the prosecution could have been brought in where the sentence, if the man got a 10 or 12-year sentence, it would have been more appropriate as to the arithmetic that took it down to 7.5 years or 8 years, okay? So you can see why I'm saying there needs to be a shift where all the parties can be taken into consideration before a final sentence is imposed, and not just the defense using an arithmetic to say what the sentence is likely to be. Senator Motley, you wanted to say something?
Yes, and I'm going to rely on the Solicitor General to correct me if I'm wrong, because the impression, as I'm hearing it, is that there's a purely arithmetic calculation by which a judge has to abide. But my recall of the Criminal Justice Administration Act is that if the judge finds that there are aggravating circumstances, he or she can abandon the formula altogether and apply other considerations. I don't want the public to be left with the impression that it's just an addition that is done. Because
with due respect, I mean, I can be corrected by the SC or anyone, but my understanding is that it's an arithmetic. What the judge can do is to say, because of the aggravating factors, the starting point of the sentence could be 30 years instead of 18.
That is why I said that I wanted to ask.
Right. No.
Because my understanding is that he or she does not have to stick with the arithmetic formula.
But the law is very clear. The law says that if he pleads guilty at the earliest opportunity, he gets 50% reduction. If he pleads guilty after the trial has started, it is 1/3. Is that my understanding, Charles?
It's not. It's up to minister.
Sorry?
Up to.
Mm-hmm.
So they don't have to get the
full extent.
The full extent of what is written there.
Minister,
but what I agree with you on, Minister, is when you look at the two methods that can be used, that in the plea negotiation, and it is one that I have used on a regular basis, where there is discussion with the prosecution as to what should be the outcome. And as you said, the judge actually gets involved because the judge does not have to accept at the end of the day under the plea negotiation. But it is more comprehensive in its approach. It requires the preparation of even the documentary evidence which supports the objectivity of what the outcome is going to be, and can involve many considerations, much more than what exists under the Criminal Justice Administration Act, and from which we have seen the outcry from society to say that they are not satisfied with the outcome.
And that's my
then
concern.
It brings the whole system into disrepute, I believe.
I think so too.
Yes,
I've seen too many cases where the outcry brings that act into disrepute. Yeah. Okay. The Jamaica Psychiatric Association, if I might even summarize the summary, they recommended close-to-home interventions, rehabilitation and recovery, and emphasized that the reason that the correctional services should have as its primary goal rehabilitation in the correctional services. It also recommended technical workshop be utilized so that more rehabilitation and skills training, psychological interventions to improve the conditions of incarceration. Then it recommended evidence-based strategies that would include care, psychological and medical care, control through appropriate restrictions being placed, appropriate use of behavior modification and pharmacological therapy, parental love and improvement of the parenting skills, appropriate affection and respect, guidance on academic vocational education, risk-based factors should be taken into consideration, personality factors such as empathy, guilt, selfishness, deceitfulness, manipulativeness, psychopathological. In other words, what the Psychiatric Association is recommended almost a psychiatric examination of the offender in determining sentence. Colleagues, that basically is the general observations. Now, if we look at page 3, a general recommendation from the Psychological Association, it is recommended that there be amendments to the complementary acts. There should be amendments to acts that address the psychosocial determinants that influence crime and violence. For example, criminogenic factors such as family dysfunction, poverty, lack of opportunities, and social injustices, and include a more holistic approach to the matter, and that incorporate a trauma-informed approach that is sensitive to traumas faced by offenders in their treatment and rehabilitation. Here again, they're looking at rehabilitation as the main consideration for sentence. Sure, Minister.
But we have not excluded rehabilitation.
No. It's always a part of the function.
Yes.
Yes. There's no doubt about that.
That has nothing to do with the sentencing.
Right. Senator Gail, I'm going to ask you to page 4, if you go through for me. So we're on page 4, and we're going to go through each, and then we can make our comments. If you start with the Jamaica Youth Advocacy Network, yeah. Sure.
So the Jamaica Youth Advocacy Network says the 1989 Convention on the Rights of the Child, CRC, ratified by Jamaica in 1991, recognizes children as a particular vulnerable group in our society, and state parties to the convention are obligated to respect and ensure equal rights of all children, given the legal binding nature of the CRC. State parties have a duty to comply with the commitments outlined in the convention. Arising from these commitments are the duties of state obligations to respect, protect, and fulfill rights under the convention. Under the CRC, it recognizes that the best interest of the child is the paramount consideration. Under Article 3, subsection 1, this presupposes that the well-being of the child is determined by several factors: age, maturity, the environment the child is in, their individual experience, and the presence or lack thereof of parental guidance. Our local Child Care and Protection Act, CCPA, further acknowledges
Page 5. Then.
the best interests of the child is a primary consideration in deciding on matters concerning the children. The CCPA further outlines extensively, but not exhaustively, the factors to be taken into account in determining the child's best interests, the safety of the child's physical and emotional needs, the continuity in the child's care, quality of relationship child has with parents, guardians, the child's religious and spiritual views, child's level of education, age and maturity of the child, to be able to form own views, and the effect of the child of a delay in making decision. The memorandum of objects and reasons for all the amendments are the same and give the following as jurisdictions for their particular punitive nature: the uncontrolled and unabated murder rate,
Page 5.
the adverse impact of crime on domestic safety, reputational damage to the country, and the impact on Jamaica's.
Then go to page 6.
GDP.
Right.
This is on page 6 now.
Yeah.
These circumstances, whether taken on their own or combined, do not justify the current amendments or the government's general attitudes when it comes to sentencing children. Deterrence and punishments are important objectives of sentencing, but they are not the only objectives. In the case of children, a balance has to be struck between those objectives and that of rehabilitation.
And to be fair, this is what we will have to take into consideration when we make our final decision, okay? We look at the balance. What they're saying is that we have to see what rehabilitation we can recommend in the sentence, which we can always say, with the mandatory minimum, we are hoping that the correctional services in the 10 or 20 years, that is the minimum, that they ensure that the child can get continuous education, or the Ministry of Justice can work with restorative justice in the prisons with them. So we have no problem saying, once there's some incarceration, what do we do while they're incarcerated? So we can put that as a part of our recommendation in our report, that with children, whatever the sentence is, the correctional services should ensure that these children get access to education, to conflict resolution skills, and whatever services, so that while incarcerated, in England they used to have a thing known as Borstal, and in the Borstal, what they did, institutions, that the children had to learn a skill. And once they learn a skill, they were open to be released. So they learned skills such as whatever the skills were inside the Borstal institutions. So that is how they catered to the juveniles in England in the Borstal institutions. So these are considerations which should be taken into whether the child during the incarceration to be granted parole after minimum mandatory, did they take advantage of these opportunities to improve their education, improve their skills, as the case may be?
What it would be suggesting, Chair, is that there would have to be an assessment or an evaluation period.
A regular
one to determine the state of readiness
of the
to
child
be brought back into society.
Into the society. No, but the point about it is that there's no doubt, but Senator Motley, the mandatory, it will help us to determine what is the appropriate minimum mandatory. Do we need 30 years for a 15-year-old or 20 years?
So in my mind, what I'm seeing and coming from a thread in the groups is that the groups are placing a heavy reliance on rehabilitation.
Absolutely.
It suggests in my mind that they are not moving away from suggesting that there ought not to be a mandatory minimum.
That is correct.
It's for us to decide and determine what that mandatory minimum
and
ought
what
to
should be accomplished within that time.
Right. So when I've asked about what are the programs, because it makes no sense that we are going to suggest or recommend programs that are already there but not working. So we have to make a determination, what are those programs and why are the programs not working? And to the effect that if it has been working, what has it done to those who would have been incarcerated and what would have been the possible outcome?
Well, you know, it is open to this committee to make recommendations. For example, if a child, 12 to 14, for example, has been convicted for murder, it may well say that there should be no minimum mandatory, or it should be 3 years, as the case may be. But during that time, you may well sentence that child to life imprisonment. You know, I'm not saying you should, but say that they should be considered for parole after 3 or 5 years. But consideration for parole may depend on certain rehabilitation as measured by did the child get CXC passes, did they develop a skill in plumbing or carpentry, did they participate in classes on conflict resolution. In a sense, this committee should make recommendation for juveniles that during the period of incarceration, there should be programs of rehabilitation and, improvements. So that's the point. We're agreeing that for the juveniles, we must make some recommendations in terms of what rehabilitation that they should be assisted with once they're incarcerated. Okay?
So here what the recommendations are. The following are being recommended on the minimum mandatory, on the mandatory minimum sentence. 1, in relation to the mandatory minimum sentence of child offenders.
But you're reading from where now?
I'm on,
this is
still
the Jamaica
on page
Bar
6.
Association.
No, Jamaica Youth Advocacy Network.
Page 1.
That's on page 6, same page 6.
Okay, under the Child Care and Protection Act.
No. Yes.
Yes, okay, go ahead.
So it says...
We don't reach there yet, no. All right, go ahead, because I think that's important.
No, man, wasn't that where we were following?
No, this
is under the Child Care and Protection Act.
So
okay.
I asked you to go back to the Bar Association on
Yes.
page 4. Page 4, the concerns.
Right, this is Jambar.
Mm-hmm. No, not on page 4. Go ahead.
The mandatory minimum ignores the community wishes where they express that the convicted persons was faced with difficulties which caused them to be in the position that they are in. Example, youth and children being forced to take part in illegal activities. It went on to state that legislating mandatory sentences ignores the cries of society for better crime-fighting initiatives, witness care programs, and lack of resources invested into the judiciary and police force. Real injustice is fair trial dates. Fair trial dates, sorry. Lack of judges, courtrooms, prosecutors, and courtization officers. Increased penalties will not be effective to fight crimes if most of the cases brought before the court have been dismissed due to ineffective investigation. There is evidence that mandatory minimum sentencing increases the incarceration rate and does not serve as a deterrent. The JBA therefore recommended a comprehensive reform of the penal system to address overcrowding and the myriad other challenges before implementing these charges. The proposed changes will reduce incentives to enter a plea guilty, resulting in an increased backlog for the courts.
And conclude on page 5.
The proposed changes will restrict judicial discretion and infringe on the principle of separation of powers.
Well, we have discussed the question of separation of powers, but you know, when the Jamaica Bar Association say the real injustice is far trial dates, lack of judges, courtrooms, prosecutors, and court liaison officers, that is going overboard. Because let me say, I never said it at the time. First of all, we have more than enough judges. Wow. We have 42 judges and 13 Court of Appeal judges, including the president. We have 60 resident magistrates. In other words, in the last many years, we have doubled the number of judges. We have doubled the number of prosecutors. We now have 58 prosecutors. And there's no lack of courtrooms. Downtown, in fact, the report from the Chief Justice is that most courts are now being utilized 80% of the time. So that's not fair. What is causing, unfortunately, the cases not to be tried on time is the lack of the forensic reports, and that is a major problem. You know, and although a fair amount of investment have been put in the forensic lab, they still lack enough staff to get these. And indeed, I think over the weekend you have seen where the Chief Justice, and there has been the debate about the Chief Justices indicating that if the court has to wait an inordinate long time for these reports to come, it is only fair to the accused, who is innocent until proven guilty, that he should have the benefit of bail. Mm-hmm. Many people don't agree, but in many ways, it is the state responsibility to have the material available in a timely manner so that the cases can be tried, because the constitutional right to a fair and reasonable time before trial has to be adhered to. And to the Chief Justice's view is that, and he has now indicated that he wants cases to be dealt with in a timely manner. Now, I know, because Senator Motley will tell you, we sit at National Council for Justice, and he has constantly requested a time period for the forensic lab, for reports to come in. And what I think has frustrated the Chief Justice in recent times is that the time period of 3 to 6 months to get a ballistic report from the forensic lab is now going into years. And he says, you know, it is frustrating, and I've seen various correspondence from him, copied to me, to the forensic lab, to the minister, to the Commissioner of Police, that it cannot continue like this. You have persons awaiting trial, and after 12 months, you don't know when the case will start because the information is still pending for the case to try it. So that to my mind is where certainly I have said that for us to really succeed as a modern criminal justice system, no case should go beyond 24 months to 3 years. But we have far too many cases now that are not started after 3-4 years. And it is not the fault of the accused. It is often the fault, respect, of the state to provide all the evidence so that the case can start. So, whereas the Chief Justice in the parish courts have encouraged the parish court and clerks, cases are now being tried in less than 12 months. In fact, they're averaging less than 12 months. Yes, 5% go over 12 months. He wants in the gun court and in the Supreme Court for cases to be tried within 24 to 36 months. But the way they're going now, when they have to wait 18 months or 2 years on the lab reports, he is and has expressed his frustration at different levels. And that is a concern which we cannot ignore, because in murder cases, you not only need the pathology report, you not only need the forensic report, but a number of other factors so that murder cases can be tried within a reasonable time. Because if they're not tried within a reasonable time, witnesses' memory could fade. You know, and that is not fair to the accused or to the state. If the witness's memory fade and he or she doesn't give the actual information that occurred, you see. So it's a concern.
So do we make that, Chair, as a general observation to be placed in the report?
I would say that in murder cases, as in all cases, the cases should be completed within 36 months. Within. Because to the best of my knowledge now, far too many cases, when you read them, the offense occurred 5 and more years. Am I wrong? You're in the practice.
Yes. And Minister, you have made some valuable and pointed comments in respect to where the delays may arise. But what we're also experiencing is also in respect to the issue of availability of jurors, which is also critical, because as it stands now, it is the right of the accused to be tried, whether by judge
those who
or
want
by
to
jurors.
trial by jury.
And I get the impression from what I've seen that most persons prefer to be tried by jurors. But I have a particular view of it, Minister, because jurors are, another term for jurors are judges of fact. So the term judges is applicable to them. But how are they treated? When you look on how the system says, jurors come to court and they sit out in a common area with persons who are potential witnesses. Persons who are on bail, they come through the same door. The stipend that they are to get at the end of the period takes months. And I suppose we have to look on those issues too, whilst we look on the others that you spoke about in respect to the forensics, in correcting those issues so that persons are more willing to participate in the whole process. You have some parishes, Mr. Minister, that when you look, jurors turn out in numbers. Trelawney is one.
Senator Sinclair, let me say.
You're getting them in Clarendon too.
Senator Sinclair,
yes,
it is a matter of grave concern. What is even worse is that I have a submission to come to Cabinet that has been doing the ring of roses for the last 2 months, 2 or 3 months. The idea was to recommend to Cabinet not only increase stipend for jurors who serve, but especially in the country areas, in fact across Jamaica, if they come to court, even if they're not called, they should at least get back their bus fare. So we're looking at that as a recommendation so that people don't come because they don't have bus fare. So we are saying once they come to court, they should get, say, $1. If they serve on the jury, they get $3 because during the course of the day, they have to get lunch and may have 1 or 2 other expenses. Well, you have some professional jurors in it, especially in the coroner's court, which we have to avoid. But people are having difficulty, especially in the rural areas, when they have to come to court and have to spend $2,000 just for bus fare or taxi fare. It's a burden, you see, and they say it's better to be fined rather than come to court. So we're looking at that as a recommendation to increase the stipend for jurors who serve, but also for jurors who don't serve, once they're called to jury service, to at least refund them an appropriate taxi or bus fare. Okay? So that's something which we're looking at. So that point is well taken, because for us to get jurors to serve is important. Could you finish up where Jamaicans for Justice, page 4?
Yes. So the potential impacts of mandatory sentencing regime include: 1, increased strain on correctional infrastructure; 2, negatively impacts rehabilitation and restorative justice; 3, breach of international laws and protection of human rights; 4, increased strain on judicial administration; 5, undermining of parole boards; and 6, parole boards; and 6, payroll is always in my mind, undermines rule of law and principle of separation of powers.
I think we've gone through this. You know, in other words, it's always a consideration in terms of minimum mandatory. But what is interesting is that Jamaicans for Justice support minimum mandatory. When they were before us, they said they didn't have any disagreement. And indeed, you will see later they recommend what the minimum mandatory should be. Okay. But I think this may have been in relation to children. Yeah. Continue.
Where am I now?
United Nations Children Fund.
So, United Nations Children's Fund. This was one of the first groups that participated. The mandatory sentencing violates the CRC. Harsh sentences do not deter offending by children. The most effective way to ensure safety is through rehabilitation, not punishment. Lengthy mandatory terms of imprisonment are cruel and inhumane and do not recognize children's greater rehabilitative potential. And imprisonment increases the likelihood of reoffending and put the public at greater risk. The proposed mandatory minimum sentences for children must be examined in relation to Jamaica's commitment under the CRC and the core human rights treaties. UNICEF shares the government's concern about the high rate of violent crime in Jamaica. However, punitive approaches are not effective at deterring offending by children, and there is no evidence that harsh sentencing reduce youth crime. Children engaged in persistent or violent crime are generally influenced by a range of social and environmental risk factors outside of their control, such as family violence, abuse and neglect, trauma, educational exclusion, socioeconomic disadvantage, drug and alcohol addiction, and mental health issues. UNICEF is strongly of the view that no child, even those who commit various violent crimes, is a lost cause or beyond rehabilitation. There's a large body of international evidence showing that imprisonment of children is counterproductive because it does not improve the public safety and, in fact, increases the likelihood of reoffending as compared to suitable community-based alternatives. UNICEF Jamaica is concerned that the proposed mandatory minimum sentence for children will shift focus from the essential root causes that may lead a child into a life of crime. UNICEF Jamaica therefore calls on the government to reconsider the proposed mandatory sentences for children.
I think we can always bear that in mind. We will take UNICEF views into consideration when we make our decisions. All right, the Office of the Public Defender.
So the Office of the Public Defender, it would appear that it is the intention that the trilogy enactments operate together. It is to be noted that there's nothing in the Criminal Justice Administration Act 23 of the Offenses Against the Persons Amendment Act 23 to prevent Section 42F and Section 3 of the respective legislation being applicable to children. Likewise, There's nothing in the Child Care and Protection Amendment Act 2023 expressly excluding the applicability of Section 42F of the Criminal Justice Amendment Act 2023 or Section 3, subsection 1B of the Offenses Against Persons Amendment Act 2023 to children. An example of an exclusion clause is identified in Section 78(1) of the Child Care and Protection, which prohibit the application of the death penalty to children. Drafters and crafters of this trilogy may wish to explore this issue in that legislation and could make specific reference to the exclusion of children. That is, Section 42F of the Criminal Justice Administration Act and Section 3 of the Offenses Against Persons Act. This would remove the possibility of an anomaly where interpretation as to the array of sentencing options is concerned.
Right. I think that we can take that into consideration to look at, okay, carefully. That was on page 4. And finally, the Jamaica Psychiatric.
All right, Jamaica Psychiatric Association. The Jamaica Psychiatric Association, whilst recognizing the grief, hardship, and despair that victims and their families are plunged into, seeks to highlight the grave challenges that children who are convicted of capital crimes must face. However, we believe that mandatory sentencing of children is not the option for deterring future offenders or reoffending. We believe, like other organizations, that children who are developmentally immature, lacking capacity to reason, and poor judges of character in comparison to adults should be categorized separately and different from adults within the justice system. This should afford them better understanding of mitigating factors relating to their situation, as such better options at rehabilitation and recovery through appropriately delivered evidence-based interventions.
A matter to be taken into consideration again, because apart from the Psychiatric Association, the United Nations, UNICEF, and Jamaica Youth Advocacy, and the Bar Association do not support the minimum mandatory, so it is to be taken into consideration. So we are going to go to page 6, the Child Care and Protection Act. Senator Motley or Senator Binns, remember I'm going to depend on you. Remember where asked. So who is going to go? Okay, so we're looking then at page 6. Senator Binns, we can start with the Jamaica Youth Advocacy Network, and then halfway, Senator Motley will take over.
Amendment of Section 78 of the Principal Act, the Child Care and Protection Amendment Act. The following are being recommended on the mandatory minimum sentence. 1, in relation to the mandatory minimum sentencing of child offenders, generally, legislators should not interfere with the rights of offenders of whatever age to be fully heard before the court. Legislators should also not interfere with the role of judges to fully adjudicate a case on its merits and have the final decisions as to what orders are appropriate in each instance. The amendments to these acts should not be passed. Where imprisonment
is considered, page 7.
Where imprisonment is considered appropriate, it should be for the shortest possible period of time, having regard to the nature and gravity of the offense and the needs of society, as well as the particular needs and interests of the child offender.
We can bear it in mind, okay? The
Office of the Children's Advocate. In relation to Section 78, subsection 3, the imposition of the need for a child to serve 20 years before becoming eligible for parole needs to be qualified or tempered by way of the incorporation of a proviso into the amended Section 78.3 of the Child Care and Protection Act. It is recommended that this general proviso be triggered whenever the trial judge forms the view that the individual circumstances of the child offender warrants an exception to the mandatory minimum of 20 years before parole. Further, a sentencing hearing in which the judge considers arguments of whether the child at bar warrants the 20-year minimum or if this should be deviated from may prove to be of tremendous benefit in cases of this nature. In the face of needing to balance Jamaica's struggle with, page 7, with high crime on the one hand and the special considerations which attach to juvenile offenders, minors, on the other hand, such a hearing may present a useful compromise. The justifications for same are 1, the best interest principle, 2, the assessment of the individual child, 3, utility of a social inquiry report, 4, the objectives of the juvenile justice, and 5, imprisonment of a child is to be for the shortest appropriate period of time.
You will see, colleagues, that there's a lot of repetition amongst the various groups.
That phrase.
Right. Faculty of Law.
It is proposed that given the policy, legal, and operational defects of the proposed amendment of the Child Care and Protection Act, it should not be enacted. The rationale for this is that it is inconsistent with Jamaica's public policy that regard children as a vulnerable and protected class, and that each child in the justice system should receive individuated treatment having regard to their mental and emotional maturity, among other factors. It may be inconsistent with the Charter of Fundamental Rights and Freedoms and likely to inundate the Attorney General with constitutional litigation in light of the recent UK Privy Council decision in the Tafari-Morrison case. It is inconsistent with Jamaica's international obligations, particularly the United Nations Convention on the Rights of the Child, and sets Jamaica as an outlier in relation to their main international partners. The concerns, relevant meaning, and effect of the proposed amendment may be summarized as follows. A child under the age of 14 years that is convicted of murder may not be sentenced to more than 25 years of imprisonment. The mandatory minimum sentence for conviction of a murder does not apply to a child under the age of 14 years. A child of 14 years of age or older that is convicted of murder and sentenced to a term of life imprisonment must serve a minimum of 20 years before becoming eligible for parole. The proposed amendment poses a serious risk to the best interest of the child who is under 14 years or older and less than 18 years. These are children of the ages 14, 15, 16, 17. The proposed amendment of the Child Care and Protection Act is not in conformity with any of the international obligations. It removes from judges the necessary discretion that ensures the legally required individual treatment of children. The bill prevents the consideration of a child's personal circumstances. It does not regard the best interest of the child as paramount. It is likely to result in children being given inappropriately long or grossly disproportionate sentences. That's page 8. In effect, the proposed amendment defeats both the letter and spirit of the Convention on the Rights of the Child, putting Jamaica in a state of willful non-compliance with her international obligations.
Concerns to be taken into consideration. You do Jamaicans for Justice, and then Senator want to do the remaining 4?
Yes. The following are being recommended by the Jamaican for Justice. It is proposed for relief of exclusion from the application of mandatory minimum penalties to juveniles and vulnerable groups. Option 1, mandatory minimums should not apply to anyone under the age 18 at the time of committing an offense. The legislative proposal is to insert provisos in Section 2 of the Child Care and Protection Act. Example, the Principal Act is amended by inserting the following. Notwithstanding the provisions of any other act on the sentencing of any child, where the legislation provides for a prescribed sentence, the court shall disregard it and provide for an appropriate sentence that considers the circumstances of the offense and accused as well as the possibilities
for rehabilitation and/or the use of child diversion. Mechanisms. Option 2. Apply mandatory minimums based on categories or tiers according to the age of the offender. Jamaican for Justice is proposing its second option in keeping with Canada's structure, but contextualizing within Jamaica's context. Legislative proposal should read as follows. Young adults mean a person who has attained the age of 18 years, but has not yet reached the age of 21 years. Legislative proposal in amending the Child Care and Protection Act to include the tiered levels, lower minimums, and judicial discretion by inserting the following. Notwithstanding the provisions of any other act on the sentencing of any child where the legislation provides for a prescribed sentence, the court may subject to subsection 5A, where the offense is murder pursuant to section 3(1)A of the Offenses Against the Persons Act, the court shall specify a minimum period of not less than 10 years for children ages 16 and over, and a minimum period of not less than 7 years for children ages 14 and over. B, where the offense is murder to section 3(1)B of the Offenses Against the Persons Act, the court shall specify a minimum period of not less than 7 years for children ages 16 and over, and a minimum period of not less than 5 years for children ages 14 and over. C, in the case of any other offense, notwithstanding a provision in any other legislation, the court shall specify a period that a child should serve before becoming eligible for parole. Notwithstanding, page 8, subsections A and B, the court can deviate from the minimum sentence if it is of the opinion that there are particular circumstances relating to the offense or the defendant which would make it unjust to impose the minimum term in all the circumstances, or it considers that there are exceptional circumstances relating to the offense or the defendant to justify not imposing the minimum term. E, where the offender is over the age of 18 but below the age of 21, the court may apply the minimum sentence unless it is of the opinion that there are particular circumstances relating to the offense or the defendant which would make it unjust to impose the minimum term in all the circumstances, or it considers that there are exceptional circumstances relating to the offense or the defendant to justify not imposing a minimum term. F, in imposing a sentence under this section, the court must have consideration for the particular circumstances of the offense and vulnerabilities of the offender, as well as the possibilities for rehabilitation and or the use of child diversion mechanisms.
Colleagues, I must tell you that, speaking personally, I found Jamaicans for Justice paper was a bit balanced. In other words, they support the minimum, mandatory minimum, but how it is imposed depends on the circumstances. I pointed out to them that indeed, if the child pleads guilty, then the minimum mandatory may not apply. They could come under the plea bargain, and an appropriate sentence can in fact be put with certain minimum before parole. So I'm going to urge, but they looked at other legislation of other countries to see how children are treated, but they admitted that they did not object. This is Jamaicans for Justice. In fact, to the best of my knowledge, they said that for the 16-17 group, 10 years, they actually said 10 years was their recommendation for the minimum mandatory, okay? But they also said for the 14 and under that the sentence, minimum mandatory, should be much less than 10 years. So at least Jamaicans for Justice supported the legislation being proposed and gave some figures, not only for children, but later on we'll see for adults. So it's something, members, that you should have a look at. Yes. Go ahead first.
Oh, it would be good to understand if they're, how they treat it, how did they align the scales in terms of any other jurisdiction.
I think if you look at their paper, they did utilize the Canadian.
Okay.
Right.
And I find F interesting because if I'm connecting it, in imposing a sentence under this section, the court must have consideration for the particular circumstances of offense and vulnerabilities. I recall us having a discussion around those children who may have been influenced or coerced by others. And I believe that is what F is seeking to align with.
Absolutely.
Yeah.
And you see, this is why the DPP, when they recommended that the plea bargain remain as is, under that, you could take into consideration all of these alternatives, such as child diversion, going through a process of child diversion and other remedial and rehabilitation methods. So that I would urge persons to, it's not a long paper that Jamaicans for Justice provided, and it should be in your, and if you don't, have a look at it. Okay. Senator Motley, you...
Yes, I wanted to know, Minister, what are the present arrangements under the Plea Bargain Act for children to be engaged by it?
Open? Totally open.
So who would then be the person to... I don't recall this section at all, that's why I'm asking. Who would then be the person to enter into the arrangement between the defense and the prosecution?
All the parties, including the guardian of the offender, the victims and the victim. So to the extent that a social inquiry report is usually, appropriate, it is all the parties. In essence, when you...
So the guardian would actually be the person who will be standing in the gap for the child.
And you would then look at what is in the best interest of that child, because if the child admits and the defense is agreed to plead guilty, then you can look at all the possibilities. You see, that is why I'm saying the plea bargain opens up every possibility. Nothing is closed.
That's no, that is what I'm trying to recall, whether that role is specifically stated in the plea bargain. That is to say that where a child is engaged,
I must admit, I must admit, I can't recall specifically, Paul, if a special attention is given for children.
There is, Minister, and it is section 7, subsection 4. It says where, my apologies. This is in relation to the victim, not in relation to the accused. So
yes.
I'll do...
Yes, what I'm trying to find out is the applicability of the recommendation to, in our present circumstances, in other words, how can a child really participate under the present structure of the Plea Bargain Act? You are not aware.
Participate as a victim or participate as the accused?
No, we're talking about as the accused.
As the offender. I'm doing a quick search through this.
Okay, thank you.
I just think my recollection is that they would be treated and take all issues, because that's the basis of the Plea Negotiation Act. All issues should be taken into consideration.
Yes, but Minister, I cannot make the assumption because it's a child. And children cannot consent to certain things.
I would think, you see, and that is something which we could, when we look at the legislation, for instance, the children's advocate or the child care and protection person, they should be taken into consideration too.
Right, but if we're going to make this recommendation on the assumption that the Plea Bargaining Act applies, we need a certain amount of clarity around it, because it might be that we will have to make adjustments to that legislation in order to bring it in, if we do accept the recommendations of Jamaicans for Justice, who have looked at what presently obtains in Canada. So I just would like to ask through you, Minister, that we be advised.
Let me look at it, and
yes,
then,
thank you.
Paul, tomorrow when we get back here, let us see if we can put a response to it. So I'll ask my office at MOJ to have a look at it.
So
Senator
you want,
Motley,
me,
you're
you
going
want me to proceed then with the...
Yes, United
so this
Nations.
is the recommendation from the United Nations Children Fund, UNICEF, and that is in relation to the amendment of Section 78 of the Child Care and Protection Act. The following are being proposed in relation to the mandatory sentence. 1, reconsider the proposed mandatory minimum sentences for children convicted of murder. A rigid approach that removes judicial discretion and individualized sentencing will not contribute to public safety or help in controlling the national murder rate. Confinement beyond the minimum period needed to deliver intensive services is not only a waste of resources, but also harmful to both the child and society, as it impedes pro-social development and successful reintegration into society. Jamaica should continue to invest in a strong, differentiated child justice system in line with international standards, with a focus on evidence-based violence prevention, restorative justice and rehabilitation programs that will have a more significant and long-term impact on community safety. 2, invest in services for children and their families to address the root causes of violent crime. Investment is needed in addressing the underlying causes of crime, including improving the socioeconomic conditions of children and their families, including ensuring access to quality education, healthcare, and social protection. Continue to invest in a strong, differentiated child justice system in line with international standards, with focus on evidence-based violence prevention, restorative justice, and rehabilitation programs.
We take everything into consideration.
Yes. And then
the Child Watch.
Yes, the other is from Child Watch, which is a legal affiliate of Hear the Children Cry. The recommendation, in relation to the amendment of Section 78 of the Principal Act, we recommend a sliding scale for children who commit murder as follows. Children between 12 and 13-year-old, no possibility of life imprisonment. 2, 8 to 12 years, custodial sentence, depending on the facts of the case. 3, parole may be considered when they have served 2/3 of their sentence. So that's for children 12 to 13. Children 14 to 15, life imprisonment, parole considered after 10 years in custody. Children 16 to 17-year-old, life imprisonment, parole considered after 15 years in custody. This should serve as guidance only. The judge should have the liberty to vary these tariffs according to the circumstances of each case. The recommendation in relation to the mandatory sentence, the likelihood of rehabilitation is being disregarded, and it is being proposed that in the event of sentencing, we take notes from our international friends who have imposed sentencing in tranches based on the age range, and having the primary goal of sentencing being that of rehabilitation. It is suggested that we invest more time and effort into programs and avenues where our at-risk youths may be positively engaged prior to joining criminal gangs and participating in criminal activities. If they have been solicited into criminal activities, we should endeavor to restore them, reintegrate them into the society with skills, and within reasonable time for them to become gainfully employed or educated, reducing the likelihood of remaining complacent and being reintroduced to crime. It is noteworthy It is noteworthy that if this bill was to become law, then when a child at the age of 12 is sentenced to a minimum of 20 years before becoming eligible for parole, then he would not be less than 32 years old before he's given an opportunity to experience freedom and a normal life. This, in our view, is cruel, excessive, and does not promote rehabilitation, which in essence should be a primary objective in sentencing. They recommend that the judge's discretionary powers is being undermined. Therefore, to deprive the court of their inherent power to assess these matters brought before them and to make a determination of a child's age, reason for committing the crime, the number of times the child was found liable for similar or the same crime, among other things, should not be celebrated. The court should be given opportunity to have a lesser sentence, that is, for children at different age groups or ranges, and the factors that contribute to the result of the child being brought before the court. It is well established that with the separation of powers, judges have an inherent jurisdiction to exercise discretion within the ambits of the law over matters that are brought before them. As such, if the bill mandates a minimum term of 20 years before parole for children, this undermines and limits the flexibility that is usually afforded to the judiciary. The judiciary, which is vested with powers and the authority to make decisions based on the merit of each case, will be tightly restricted to impose a sentence despite the facts of the case. This is unreasonable, and certainly indicates a disregard for the rule of law where Parliament is manipulating the hands of the court.
Well, you know, as you can see, there's ambiguity in what, there's no doubt that the Child Watch, first of all, they did support minimum mandatory. No, they do, but they were really just saying 20 years is unreasonable, to be frank. Because if you can see, they're even indicating for the age group 12 to 14 that there should be minimum mandatory, while there are other groups that don't think that there should be minimum mandatory for the 12 to 14 age group. So, colleagues, it is something to bear in mind that the Child Watch, they do support some minimum mandatory, as you can see at the beginning, but they think 20 years is too high, and it should not apply to the range, you know, for the 12 to 14. So we can bear that in mind.
But, Minister, they do go on to say, after making that as you say, the tariffs, they do say it should only serve as guidance.
Sure,
and
admittedly.
that the judge should have the liberty to vary these tariffs according to the circumstances
and,
of each case. So
they were trying to balance.
Yes.
Chair, that is where I'm grappling in my mind, that we're proposing to establish some tariffs or schedules on the one hand, but on the other hand, we're still giving the judge that mode and right to offer flexibility and determination. In that case, one would have to consider, in the first instance, setting a standard as a minimum standard, and then offer some sort of a lower threshold to which you can't pass.
Well, you know, Senator Ging, it's a matter for us. It is a matter that we should bear in mind. I have my own views, which I'll express soon. Okay, and just Minister Williams would like to.
Chairman, thank you. I just, again, as I'm reading through what the Child Watch legal affiliate of Hear the Children Cry is saying, it just, in all of these cases, we always seem to forget the victims.
Yes. That
somebody lost their life. We keep feeling sorry for the perpetrator.
So, and colleagues, what Minister Williams is saying, we have to take all the issues into consideration.
Yeah,
it
but
cannot
even in
be.
this submission, they're saying, oh, you have to take into consideration the number of times the child was found liable for similar crime. I mean, come on.
So, Chair, one of the main objectives of this committee is to seek where we can balance justice. You have the call and the cries from the victims on the one hand, and most, if not all, of the groups have represented in defense the perpetrators. And so the committee has to focus now on how do we balance justice? How do we satisfy and serve the needs of the victims on the one hand and balance it with the perpetrators?
No, there's no doubt about that. We have to bear all the factors into consideration. But at least Child Watch supports the mandatory minimum, but delineates the periods. Now you find Santa Marta, when you go to the next one, the Office of the Public Defender, they even go further in terms of the delineation. So we could...
Yes, that's why I didn't want to read,
One second, yes, right. one second, Senator.
Mr. Chairman,
Minister.
we should not lose sight of the fact, based on this data we're presented with, that over the last 6 years, 47 children were charged for murder, right? And that's what this data is telling us. That's approximately 8 every year over the last 6 years. Right?
That's correct.
Yeah. So it is of significance that in terms of the consideration.
There's no
that
doubt
we're
about
given.
that. Mm.
But 8, I don't know if the minister understands that 8 children being charged every year does not mean 8 children are guilty.
No.
And that in the scheme of things, 8, as they say, is a very insignificant number.
But it's not insignificant
the
to
minister
the
has to take
victim.
into account the nature of the charges, the facts.
But
let me say that what surprises me, is that the minister, more than anybody else in this room, ought to be acutely aware of what the situation which affects children, because she looks at it close up in the schools. But I'm not going to press. I'm going to go on to read. I'm going to read the Office of the Public Defender.
We bear that in mind when we come to that discussion, which could be soon.
So the recommendation...
I'm so sorry.
Sorry.
Might I just make a comment? I must admit, I understand the positions being expressed by my colleagues, and I share them. But I just want to get some clarity as to where we're going and what our intent is. The bill that we are deliberating on and about is intended to create mandatory minimum penalties for the offense of murder. We are grappling with the issue of that intent as it relates to children. And I hear you, Minister, on the public outcry, and I hear and agree that we have to consider and contemplate the impact of victims. But I really am going to impress upon my colleagues that we look at the data we have and we take the data and information that we have been given into more prominent consideration, so that when Dr. Shetty from the Jamaica Psychiatric Association came and spoke to the committee, he spoke to data that is extremely relevant to the consideration of children and the state of mind of children and how we should be looking at penalties in relation to them. We seem to have ignored that. And I'm concerned that we are operating on the basis of public outcry is an important thing to consider, but we are, I hope, going to make law on the basis of what the data is saying is the prudent path to take.
Absolutely.
With respect.
But anyway, continue.
So that we're at the Office of the Public Defender, and that recommendation in relation to Section 78.3 says if there has to be a statutory minimum sentence of imprisonment on a minor convicted of murder, then it is suggested that there be a categorization of minors in two groups. A, the persons who have attained the age of 14 years but are under 18, and persons under the age of 14 years but not duly incapax, so they don't have the mental capacity. Category B is consistent with the definition stated in the Child Care and Protection Act. If indeed a statutory minimum is a must, then such an imposition should, it is suggested, be made applicable only to persons falling in Category A and not those at B. For children aged 12 to 14, a court must be able to take into account their age, maturity, and circumstances when determining the appropriate response to their actions. The concerns, the Office of the Public Defender recognizes that a number of heinous crimes are being committed by children and young persons in Jamaica, including within the walls of school compounds. However, mandatory minimum sentences can create unnecessary problems for the judiciary and leaves judges hamstrung in addressing the peculiarities of a given case. It cannot be gainsaid that this procedure, that is, that of going to the Court of Appeal, adds another layer to the process of judicial proceedings in criminal law, even where the defendant would have saved judicial time by pleading guilty. One suspects that the Court of Appeal itself is beset with a backlog of cases in the same way other courts are. Further, that child would perhaps remain in custody until the issue of sentence is remedied, whilst all administrative matters are put in place, for example, preparation of a transcript for an appeal. Under Article 37B of the United Nations Convention on the Rights of Child, to which Jamaica is a signatory, it is recognized and expressed in clear terms that the arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time. In principle, Jamaica's international obligations mandate that imprisonment of children should be avoided as much as possible.
May I just say, for my part, the Office of the Public Defender encapsulate the position that I would like delineated, if I can convince my colleague, to separate the 12 to 14, that age group that the minimum mandatory shouldn't apply. But 15 to 17, it should apply. But then we determine what would be the appropriate minimum mandatory. At all times, bearing in mind that for the 12 to 17, once they plead guilty, all issues can be taken into consideration. You see? So that plea bargaining negotiation, which the recommendation of the DPP should not be adjusted in any way. So for that child 12 to 17, on a plea of guilty, then apart from a social inquiry report, we would take all the issues into consideration, guided by, no doubt, whatever the minimum mandatory is, should be taken into consideration in determining the appropriate sentence. But obviously, it's clear to me that, especially for the 15 to 17, even for the 12 to 14, some incarceration would be appropriate. And the reason why it is appropriate, you cannot ignore the fact that if the child is not incarcerated, the public outcry, can't ignore that. The victim, who could well be another child, the family of that victim will want to say, my child is in the grave, but this person is out on the street walking. You cannot ignore that balancing. So when we come to make a final decision, it may well be, it's not a minimum mandatory. It may well be that a process of incarceration, and after a certain satisfactory rehabilitation program is satisfied, they are released. But I can see in the initial stages, to say that the person is not incarcerated is going to create major problem, especially for the families of the victims who feel that the state has not given their child or their family justice. So I want colleagues to bear that in mind. We cannot ignore those considerations.
Well, one group had suggested that they be incarcerated in an institution that treats with children. The fact that if that child had committed murder and is not taken away to face rehabilitation, there's the likelihood that that child may in fact commit the offense again. Because that child may have been again encouraged or coerced.
Well, right. To be fair,
or influenced.
To be fair, Senator Gale, children between the ages of 12 and 15 are rarely put in adult institution. They go into, children's home. So that is where hopefully recommendation as to how you treat them before and what they must satisfy before they're released, or whether at age 16 they go into an adult institution or 17, as the case may be. Then these are matters. In our report, we can make recommendations, okay? Final one.
Minister, just one observation before. So if they are sentenced to 20 years.
It's a matter for us,
Yeah,
to make the recommendation
just to think
to Parliament,
about it. So after they reach 18, they can't have the benefit of the recommendation that Senator Gale just made.
First of all, the Child Care and Protection Act for children under 15. Can you guide me on that, SG?
No, but I'm saying
I don't think the sentence can be greater than 25 years.
No, I'm just saying that when they pass 18 now, you can't keep them in a children's facility.
No.
So they are actually going into the adult population with still another 15 years or more to serve.
Well, the point about it, Senator Motley, if we say that there's no minimum mandatory for, say, 12 to 14, but parole would only be granted where they have been rehabilitated.
Yes, I'm with you on that.
So if they're not rehabilitated at age 20, they have to go to, if they still remain aggressive and, then you just have to keep them incarcerated, because otherwise they become a danger to the society. So I'm saying that even for the 12 to 14.
I'm with you on that one. I just was going to the other.
Right. Okay, let's go.
So let's finish with the Office of the Director of Public Prosecution. The proposal is that, Section 78.3 is deleted, and it is amended to provide that, notwithstanding the provisions of the Parole Act, when sentencing a child under subsection 1, the court may, subject to subsection 5, impose a minimum period of 20 years imprisonment before being eligible for parole in the case of murder, for which a sentence of death may be imposed, and in the case of any other offense, for the court to specify the period of imprisonment for pre-parole eligibility. So the effect is that the amendments now impose a mandatory minimum in respect of a child for the offense of murder, where formerly the court has had a discretion as to what sentence to impose. However, it is noteworthy that Section 78.5 has not been repealed or amended, so that there is, in fact, a ceiling of 25 years that can be imposed if a sentence of imprisonment is the most suitable sentencing option. Perhaps that omission may have been an oversight. However, it seems rather unusual to impose a mandatory minimum of 20 years while leaving a ceiling which only exceeds the minimum by 5 years. Further, there is
it should be the maximum. No, sorry. The minimum.
Yes, it's correct. Further, there is no distinction between the various types of murders, having regard to the careful delineation between capital murder and other murders, which is seen throughout the OAPA and the companion legislation, this omission is discordant and ambiguous. Admittedly, the sentence of death cannot be passed upon a child, but it can be argued that there's no consideration for the severity of the type of murder insofar as the appropriate sentence is concerned. As is evident from the case of Tafari Morrison, proportionality and individuation in the sentencing procedure are critical aspects of constitutionality. For this reason, some account should be taken of the differences between offenders and offenses. The case of Tafari Morrison is instructive in respect of the constitutionality of the imposition of a mandatory minimum sentence upon a child. In Morrison, the appellant appealed the dismissal of his appeal by the Court of Appeal of Jamaica to the Judicial Committee of the Privy Council against the imposition of the minimum sentence of 15 years imprisonment on the wounding with intent with the use of a firearm count, on the basis that the sentence was prohibited by the Charter of Fundamental Rights and Freedoms.
Right, PG.
Yes. So that the Constitution, right, it was therefore unlawful. The proposed amendments must therefore be assessed in accordance with the test applied in Tafari Morrison. The board outlined how the question of constitutionality should be assessed in detail at paragraphs 50 and 51, where it said, at 50, the legal approach to the determination of the constitutionality of a minimum sentence is quite different. The court must determine whether the imposition of the minimum sentence constitutes inhuman or degrading punishment or treatment. Such treatment is contrary to the Universal Declaration on Human Rights, the United Nations Convention on Torture, the ICCPR, the ACHR, and Article 3 of the ECHR. The protection against such treatment is typically a feature of every Caribbean constitution. 51, the test for such a finding is stringent. The issue is whether the imposition of the sentence is grossly disproportionate. The cases provide an indication of the stringency of the test. In Race and the Queen, the issue was whether the mandatory death penalty for murder was inhuman or degrading and therefore prohibited by the Constitution. The board considered that to deny the offender the opportunity to persuade the court that the sentence of death was disproportionate was to treat him as no human should be treated and to deny his basic humanity. However, it should be noted that an examination of several jurisdictions across the world would suggest that mandatory minimum sentences for child offenders are not common or even encouraged. A step in this direction would require a statistical approach to justify that indeed longer periods of detention are needed to effect proper rehabilitation of youth offenders. The issue of mandatory minimum for a child should only arise in capital murder cases, that is, murder falling within Section 2.1 of the Offenses Against the Persons Act. Therefore, we recommend that the proposed amendment to Section 78 of the Child Care and Protection Act be limited to where the offense is murder, falling within Section 2.1 of the Offenses Against the Person Act, specify a period of not less than 20 years which that child should serve becoming eligible for parole, notwithstanding Section 3 of the Offenses Against the Persons Act. Further, it is our submission that Section 3B should then read, in the case of any other offense or murder not falling within Section 2.1 of the Offenses Against the Persons Act, specify a period which a child should serve before becoming eligible for parole. We would recommend that as part of the future legislation reform, that consideration be given to creating a proper rehabilitation program for youth offenders who are serving a mandatory minimum sentence for capital murder. We take this approach as capital murder is an egregious offense and one that significantly affects the public. Further, there may be persons who would seek to use a child to commit murder that falls within Section 2.1 of the Offenses Against the Persons Act because of the lax sentencing regime, and therefore, the imposition of a mandatory minimum would seek to reduce such persuasion by adults while serving as a deterrent to potential child offenders in general. Having regard to these principles, the proposed amendments satisfy the test of constitutionality. The legislative framework and objectives that apply to the offense of wounding with intent also applies here. However, to ensure that children are not subject to inhumane treatment, we are recommending that a review of Section 42K of the Criminal Justice Administration Act 2015 be done. It is our view that there may be from time to time where a child offender finds him or herself committing the offense of capital murder, but nonetheless has factors which may cause the imposition of a mandatory minimum to be inhumane, unfair, excessive, or unjust. In those circumstances, without any reprieve, the sentence may be deemed as unconstitutional. However, a mitigating move could be to amend Section 42K to read, where a defendant has been tried, or in the case of a child within the definition of Child Care and Protection Act, either pleads guilty to or is convicted after trial for an offense punishable the proposed amendment would seek to ensure that no child is unfairly punished for any offense, as there may be from time to time special and exceptional circumstances that may warrant a departure from the mandatory minimum sentence.
Wonderful. Thanks, Senator Motley and Senator Binns. The remaining 5 or 6 pages deal with the Criminal Justice Administration Act, which we are going to leave till tomorrow. But colleagues, and we are going to ask the technical team to assist us when we come to discuss tomorrow. The first thing tomorrow, by the way, we would like to do is to approve, pass the minutes, okay? So please, there are 5 minutes we want to approve by in good time. And then colleagues, colleagues, we want to come to some decision based on the children. What is the recommendation we are going to put in our report? I hope we can have a consensus, okay? And then immediately after that, we then look at the remainder of those bills, which we hope can be dealt with tomorrow.
I just want to urge members to really look at the minutes. I attempted to do so, I'm not saying as thoroughly as one would like, but in preparation for the meeting.
Tomorrow.
And there is some very important information within which would guide us. For example, I know Senator Golden Campbell made reference to Dr. Shetty's observations. And I think that's a very important observation. And I think there are others within the minutes which would help us to come to a decision.
So what I'm begging members, please, for tomorrow, which could be our final meeting, believe me, tomorrow, 2 o'clock. Tomorrow could be our final meeting. I think tomorrow is a question of decision. We have to just make some decision what we recommend to Parliament. Okay? Sure.
Is it? I know I had asked from as far back as July about the correctional services, and then heard Minister Williams echoing it today. We won't have a chance to hear from them in relation to what programs they have.
I'm going to speak, check with Minister Cuthbert to see if there's anyone who could at least give us a synopsis of what rehabilitation programs they have.
Right.
Remind me to just send a note. Okay? Paul, just remind me to speak to, at least a synopsis of what program of rehabilitation they have for juveniles in the prisons, okay? And even if it is a one-pager for us to take into consideration. But colleagues, I'm going to ask you, and I will also speak to, and please, could we speak to those colleagues of ours who may not be here, if they can be here, so we come to some decision of recommendations. So remember tomorrow, please, 2 o'clock, approval of the minutes, some decisions on what recommendation we make for juveniles, and finally, we look at the penalties for under the other offenses for capital. A point to note, colleagues, you notice the DPP is making a distinction and capital murder for juveniles. So please note that. Thanks again, everyone. If you can I have a motion for adjournment. Meeting adjourned. And thanks, members of the technical staff for being here. AG Department, MOJ, CPC, and Law Reform. Thanks for being here.